Look, we've moved the ball on this. Last March, talked about spying at some length. We're not going to, revert back to that particular time frame. I've done that. Spent a lot of time talking about you can't indict a sitting president. We advanced the ball on that issue, too, as you know now. Everybody repeats that, and that's a good thing. On Hannity last Thursday, I also made the point that the President of the United States needs to appoint a U.S. attorney. Just pick one of the U.S. attorneys to investigate what took place in this election in terms of federal interference, the spying, the FISA court, and so forth. The President of the United States, who watches the Hannity show religiously, obviously took what I said, but did even something better. He didn't wait for Mueller to report to the Deputy Attorney General. He simply told the Justice Department, investigate this. And apparently, at least to some extent, Rosenstein has agreed. We'll get into that a little later in the program. There's something, actually, that is very, very important that I want to discuss with you. And that is the appointment of Robert Mueller in the first place. The appointment of Robert Mueller violates the United States Constitution. And every subpoena, indictment, and plea agreement should be viewed as null and void. I'm not saying this, again, to be provocative, but we're going to lay it on the table. I hope every lawyer who's involved in this investigation is listening to me, whether they serve the president or any of the defendants in the case, or any suspects or any witnesses, because you have a very strong constitutional argument to make. And I want to walk you through this because you're a smart audience. That's why you're here. I could just go through the websites and hit all the talking points and all the links and so, but you want more than that. And first, I want to give a significant hat tip to a very dear friend of mine. We worked together in the Meese Justice Department. He was special counsel, a real special counsel, not the Mueller type, to the Attorney General, Ed Meese, in the Reagan administration. I was chief of staff at the time. And he went on to be a superb law professor at Northwestern Law School. So over the weekend, he put together an opinion. Very well searched, 16, 17 pages, relevant footnotes, case law citations. And he said, look, let me lower this here. The appointment of Mueller, particularly Mueller, violates the Appointments Clause of the Constitution. It violates the Appointments Clause of the Constitution, which is in Article 2. Here in part is what he wrote to me. Robert Mueller has behaved like all the United States attorneys. They are principal officers of the United States. Principal officers, not inferior officers. We'll get to this distinction in a moment. It's crucial. All principal officers must be nominated by the President of the United States for consideration by the United States Senate, which will either reject or confirm. Mueller has not behaved like an assistant United States attorney who's an inferior officer and who may be appointed by a principal officer like a deputy attorney general like Rosenstein. Mueller's appointment is, therefore, unconstitutional. Under Chief Justice Rehnquist, the late Chief Justice Rehnquist, majority opinion in Morrison v. Olson back in 1988, because it takes away, quote-unquote, too much executive power from the president. In other words, the president doesn't even have the opportunity to nominate because Rosenstein essentially seized the presidential power to nominate a principal officer and cut out the Senate. It is unconstitutional because Mueller does not have a boss who is supervising and directing what he's doing. So he's not an inferior officer. You know, the bureaucracy is filled with inferior officers. That is, we're not saying they're inferior human beings, inferior as opposed to principals. Principals are required to get Senate confirmation. Inferior appointees are not. We have a bureaucracy with 2 million people. The overwhelming majority, the vast majority, are considered inferior. They're not presidential appointments. And in the case of the Deputy Attorney General, he has deliberately abstained from playing a significant, daily, regular management and oversight role over Mueller. In fact, he's basically a rubber stamp. The appointment of Mueller in the first instance was extraordinarily broad, but it's only gotten broader since. Now, here's what the Appointments Clause of Article 2 says. I'm walking it through with you, because this will become an issue down the road, starting tomorrow, the next day, and the next day. So you heard it here first, and I want to go through some of what my friend wrote to me. The Appointments Clause of Article 2, here's what it says. The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior offices as they think proper in the President alone, and in the courts of law, and in the heads of departments. In other words, you have levels of these principal officers who are required to be nominated and confirmed by the Senate in order to hold these principal positions. And then you have all the rest who serve them. Principal officers are selected by the President with the advice and consent of the Senate. Inferior officers, Congress may allow to be appointed by the President alone, by the heads of departments, or by the judiciary. Let me give you a perfect example. The Department of Justice. Let's take the mothership, the Department of Justice. The Attorney General of the United States is a principal officer. In order to serve in that position, you must be nominated by the President and confirmed by the Senate. The Deputy Attorney General of the United States, the lower next level, must be nominated by the President and confirmed. They are considered principal by the Senate. The Associate Attorney General of the United States, the number 3 down, must be nominated by the President and confirmed by the Senate. Then you have a number of Assistant Attorneys General for antitrust, for civil rights, and so forth and so on. Even they are considered principal officers. They can only serve in those positions if they are nominated by the President of the United States and confirmed by the Senate. Every single United States attorney in this country has to be nominated by the President of the United States and confirmed by the Senate. Not assistant U.S. attorneys, line attorneys, and so forth, because their day-to-day activity is managed by the United States attorney. The United States attorney. But they have a number of assistant attorneys general, depending on the size of the office. And they, of course, are not principal officers. They do not need to be nominated. So is Mr. Mueller more like an assistant U.S. attorney or more like a United States attorney? Is there a United States attorney in the country more powerful than Mr. Mueller? Not one. Particularly under the so-called management of Rod Rosenstein, which is nearly non-existent. It has been long-standing practice of Congress and the executive branch to give principal officers a status to all important and powerful public officials, even if they have a boss who can fire them. So, cabinet secretaries have always been treated as being principal officers, even though they can be fired by the President. Deputy and assistant cabinet secretaries, all of whom must be nominated and confirmed by the Senate, are also principal officers, even though they can be fired by the cabinet secretary they report to, as well as the President. But their jobs are considered important. So it's unthinkable, for example, he writes, that the deputy secretaries of state or of defense or of this Department of Justice could be made an inferior officer on the say-so of their bosses. These officials simply exercise too much power to be denominated inferior officers. They are instead principal officers who must be nominated by the President and confirmed by the Senate. That's your Appointments Clause. Even the federal judiciary. We find that federal court of appeals judges and federal district judges have always been treated as being principal officers, even though their decisions can be overruled by the Supreme Court. No one thinks, or should think, that Congress could vest in the Supreme Court the power to appoint lower court judges or inferior judges. It's obvious that lower federal court judges must be principal officers nominated by the President and confirmed by the Senate, even though their very existence isn't even in the Constitution. And it's obvious that Robert Mueller is behaving much more like a U.S. attorney then he is behaving like an assistant U.S. attorney. Mueller has acted and has behaved like a principal officer, even though he was never nominated by the president or confirmed by the Senate. Now, I've said that 5 times because it's important. The text of the Appointments Clause in your Constitution and the use of the word inferior elsewhere in the Constitution makes it clear, says Calabresi, that there are 2 prerequisites that must be met for someone to be an inferior officer and therefore not subject to nomination or confirmation. First, one must have a boss who the inferior officer reports to who can direct or fire the inferior officer. Okay, fine. The second, an office cannot be inferior if the officer exercises as much power as is exercised by every United States attorney and even more, and the deputy and assistant cabinet secretaries, or even more. This second test as to officer inferiority is somewhat subjective in close cases, but it's very real nonetheless. If a prosecutor has as much power as a U.S. attorney, he's by definition a principal officer of the United States who must be nominated by the president, confirmed by the Senate. Now, obviously, there are differences. In some ways, the U.S. attorney is more powerful in terms of the breadth of what he can investigate, or she. But in some ways, Mr. Mueller is more powerful in the nature of who he is investigating and how he's investigating them. So the issue isn't an exact parallel. For instance, a U.S. attorney has to be nominated and confirmed. An assistant secretary of agriculture has to be nominated and confirmed. The point is the breadth of their power that they exercise and the impact of that power, and whether or not they are truly effectively under the management control of somebody else. And even so, it depends on what kind of control we're talking about. An assistant secretary of agriculture reports to the Deputy Assistant Secretary of Agriculture, who reports to the Secretary of Agriculture. So it's understood that we're not just talking about the heads of a department, the heads of an agency, or in the case of a U.S. attorney, the heads of an office. Is there any question about Mr. Mueller's power? Justice Scalia, Professor Calabresi points out, summarizes the history of the Appointments Clause in Edmund versus United States from 1997. He said, as we recognized in Buckley versus Vallejo, that was a free speech campaign contribution case in 1976. The Appointments Clause of Article 2 is more than a matter of etiquette or protocol. It is among the significant structural safeguards of the constitutional scheme. By vesting the president with the exclusive power to select the principal non-inferior officers of the United States. The president, not the deputy attorney general, the president. The Appointments Clause prevents congressional encroachment upon the executive and judicial branches. This disposition, this is Scalia, was also designed to assure a higher quality of appointments. The framers anticipated that the president would be less vulnerable to interest group pressure and personal favoritism than would a collective body. Hamilton wrote in Federalist 76, the sole and undivided responsibility of one man will naturally beget a livelier sense of duty and a more exact regard to reputation. The president's power to select principal officers of the United States was not left unguarded. Of course, under Article 2, it further requires the advice and consent of the Senate. This serves both to curb the executive abuses of the appointment power and to promote a judicious choice of persons for filling the offices of the Union. So the appointment of Mueller, in my view, and Calabresi's view, fails on 2 fronts. Number one, the Deputy Attorney General doesn't get to make an appointment of a man that's so powerful, of a public official, and therefore usurp the power of the president. Only the president can nominate such a person. And number two, it undermines the power and the role of the Senate under our Constitution because they get a bite at the apple, too. They get to determine whether or not that official should serve or not. And this is why it is amazing to see senators, Republicans, running to vote to protect Mueller. They do not even understand the Department of Justice memoranda when it comes to you cannot indict a sitting president, yet they want to protect the man. They do not understand separation of powers and the Appointments Clause. And these are people, you're lawmakers. Now, I'm going to take a break. Stick with me. We're going to keep walking through this. I can't go back to what I just said in order to have everybody catch up every segment. So keep in mind where we are. We're going to proceed from there. I'll be right back.
Mark Levin.